From the studios of Boise State Public Radio News, I'm Gemma Caudette. This is Idaho Matters. Late last month, a federal judge temporarily cleared the way for emergency abortion care at one of our state's largest hospital systems. The ruling allows St. Luke's Health System to provide abortions in emergency situations, despite our state's near total abortion ban. Now, at the heart of the issue is a federal law known as EMTALA, which requires hospitals to stabilize emergency patients. Peg Doherty is St. Luke's Deputy General Counsel, and she is joining us now to take a closer look at this legal battle and what it means for patients and providers in our state. Peg, thanks so much for coming back on the show.
Gemma, thank you very much for having me.
So, Peg, just remind us, what is EMTALA?
Sure. So EMTALA, as you said, it stands for the Emergency Medical Treatment and Labor Act. And it is a federal law that requires that hospitals receiving Medicare funds and also having a dedicated emergency room must provide stabilizing treatment to patients who arrive with emergency medical conditions.
Okay. And so clarify then the argument that abortion care qualifies under this federal law.
Sure. The EMTALA law conflicts with Idaho's abortion law because when a pregnant woman arrives at one of our emergency rooms and is experiencing severe complications, termination of the pregnancy is occasionally the sole treatment that can stabilize that patient. So in the worst cases, an abortion is necessary to prevent her death. In other cases, the pregnant patient's life is not at risk, but termination is the only way to prevent serious harms like kidney failure or stroke or infertility or other life-altering impairments. And Idaho's abortion law only allows the termination of that pregnancy to prevent the pregnant patient's death. So an abortion that would prevent harm short of death under Idaho's law is considered a felony, and the physician is subject to 2 to 5 years in prison for violating that law.
So if I'm hearing you right, Peg, and I kind of want to make a comparison here, if I can.
Sure.
A pregnant woman comes in, she is in, she's in an emergency situation health-wise. So whether it's her health, as all of these conditions you mentioned, or the only way to save her life is an abortion. 3 weeks ago, I had an emergency medical situation, and I ended up at the ER at St. Luke's. I had to have my appendix out, and they gave me that stabilizing care. That is under EMTALA. I mean, they had to provide that care to me because if not, I could have died. So I know they're separate issues. However, that's emergency management for a patient who comes in whose life could be in danger. I mean, they could have not removed my appendix, I guess, and maybe I would have been okay. But standard of care is to remove the appendix.
Yeah, that's such a great example. And I'm glad that you got the care that you needed. It sounds like our physicians in our emergency room did exactly what was necessary. I think that it's important to explain that under EMTALA, that stabilizing care that we're talking about, it includes care that would that would stabilize conditions that place the patient's health in serious jeopardy, or if there may be serious impairment to bodily functions or bodily organs. So EMTALA applies not only in circumstances where a person may suffer death, but it applies in circumstances where intervening medical care can stop the disease process, can stabilize their health so that nothing more severe occurs. So it's pretty expansive, that requirement under EMTALA to stabilize a patient.
So give us some more context on why this legal battle is going on. Because if I remember correctly, didn't this begin with the Biden administration suing the state of Idaho, basically saying Idaho was not enforcing EMTALA?
That is quite correct. Back in August of 2022, when Idaho's trigger law went into effect, and just a little further explanation of a trigger law, when the Supreme Court issued the Dobbs decision, which overturned Roe v. Wade and returned to states the regulation of abortion care. Some states, Idaho being one of them, already had laws on the books that said if Roe v. Wade is ever overturned, our law goes into effect. And that's why we call it the trigger law. So our law was to go into effect in August of 2022. The United States, at that point in time, filed a lawsuit against the state of Idaho saying that Idaho's strict abortion ban law conflicted with the federal EMTALA law. And so when that lawsuit was filed in federal court, the court ruled that the court agreed with the United States, and it issued an injunction that said that Idaho's abortion law could not be enforced for cases that fell under EMTALA. So for those emergency cases of patients presenting to emergency rooms needing to have their health stabilized, the state could not enforce its abortion law.
So then it's okay if you need to take a drink of water. I totally understand. However, in early January, your organization filed another complaint. Now, tell us, Peg, why you did that and what the complaint said. Because when you filed this, and please correct me if I'm wrong, that injunction was still in place, yes?
It was when we filed it. We were concerned that under the new administration, because the new administration had said many times that it it believed that states should be enforcing abortion laws. So we expected them to move to dismiss their lawsuit. And our fear was that if the United States did that, the injunction would no longer be in place, and Idaho patients would therefore be at risk. And therefore, we filed our lawsuit hoping that the court would recognize the potential for a gap and grant us a preliminary injunction. As it played out, the United States stipulated, along with the state of Idaho and Idaho's legislature, to dismiss their lawsuit the day before our case was to be heard in federal court. And so we filed a motion for what's called a temporary restraining order, which is it's a request to the court to enjoin certain actions immediately. The court did grant that temporary restraining order, which really mirrored the injunction that the United States had in place. So there was no gap in our ability to provide stabilizing care to patients who presented to an emergency room.
So the Trump administration, as you thought might happen, ended up dropping the lawsuit, as you mentioned. So then on March 20th, federal judge B. Lynn Windmill, what does he decide?
Right. So Judge Windmill heard oral argument both from St. Luke's and from the AG's office, and Judge Windmill issued an injunction as it applies. Excuse me.
Oh, no
Issued
worries,
a,
Peg. Please take a drink of water if you need to. We can pause for
sorry
a
about
second.
that.
I totally, you know what? It's live and this happens sometimes, so I completely understand. So
Oh
you
gosh.
just when you've got your throat cleared, we will continue.
Okay, great. Thank
All
you. I
right.
appreciate
Oh,
that, Grace. Um, so Judge Windmill did issue an injunction as we requested. However, the injunction that he issued was limited to St. Luke's as the plaintiff in the case. So it applies to St. Luke's and to St. Luke's providers. And it is very similar in that it enjoins the state from enforcing Idaho's abortion law to the extent it conflicts with EMTALA.
Peg, before we go into what this injunction means for patients and providers, I kind of want to talk about what St. Luke's looks like as a health system in the state of Idaho. What I mean by that is you do have locations around the state. Can you talk to us a little bit about that and where these locations are? I mean, of course, we know downtown Boise, we know Meridian. There are other locations in the state.
Sure. Yeah, we have a hospital with an emergency room in Twin Falls, in Wood River, in Jerome, in Mountain Home, in Nampa, and in McCall, as well as in Meridian and in Boise. So our footprint really is across the southern part of the state.
And Peg, with EMTALA, now for someone, and with this injunction, and explain this to me. So as you mentioned, you mentioned all of your locations that have emergency rooms.
Mm-hmm.
So in order for someone to get this care, would they have to go to one of those facilities that has an emergency room? And why I'm asking this is, let's say a pregnant woman goes to her OBGYN, who is a St. Luke's provider, but they're not practicing in the emergency room. They have a private office.
Mm-hmm. Yeah, in those situations, EMTALA does not apply. EMTALA only applies to care in emergency rooms because it is designed to address emergency medical conditions. So if a patient presented to an OB's office with an emergency medical condition, it is highly likely the recommendation would be to immediately transport that patient to an emergency room so that they can receive emergency medical care.
Okay. The reason why I wanted you to explain that is this. Let's say a woman lives in Idaho Falls. You don't have a hospital in Idaho Falls with an emergency room. I believe the closest one would be the one in Wood River Valley. That is 139 miles away from Idaho Falls. That is roughly about a 2 hour and 20-minute drive. How does that impact someone in East Idaho if they are having this emergency medical situation?
Yeah, that is a concern, certainly for, and should be a concern for any pregnant patient, because the limitations for hospitals that are not part of St. Luke's right now are as articulated in Idaho's abortion law, and that is that an abortion may be performed if, in the physician's good faith medical belief, that it is necessary to prevent the death of the pregnant patient. So, certainly, a pregnant patient presenting to an emergency room in Idaho Falls, if a physician there felt that abortion was necessary to prevent that patient's death, then that physician would be within the scope of Idaho's abortion law. Our
Hmm.
concern is for those cases that are short of death, when abortion is a recommended treatment to stop any serious health implications based on the complication of the pregnancy.
So even though there are going to be events like that, where someone who does not live close to a St. Luke's emergency room is there, they are going to find themselves in these situations. However, what does this injunction mean for patients who do need this emergency care and they do have access to a St. Luke's emergency room?
Right. Thankfully, for our St. Luke's emergency rooms and our emergency L&D teams, they are going to be able to explain the full spectrum of care that is available to a patient who has a serious pregnancy complication and is in an emergency situation. And that full spectrum of care could be that to prevent harm to future reproductive capability, an abortion is recommended. So, in a St. Luke's facility, our providers are going to be able to provide that care. In consultation with the patient, they will be able to explain why, and the patient will be able to make that decision, and they will be able to perform that termination here in Idaho at that facility where the patient has presented.
Peg, I am going to assume that you are appreciative of the injunction being put in place and having the ability to be able to provide emergency care. However, what does limiting the injunction to just St. Luke's and St. Luke's medical staff do in regards to patients who can't access a St. Luke's emergency room quickly?
It is a grave concern. As a matter of fact, when St. Luke's filed its motion for a preliminary injunction, we asked the court to enjoin all actions in any emergency room. However, the court said that it could really only address the harm that was presented to it. And it was St. Luke's harm that was addressed. But we do have a concern about all of the people in the state of Idaho facing this potential of delayed care, because if they present to their local emergency room and they're not able to get the necessary care to prevent harm to their health, then they are likely going to be transferred out of state or possibly to a St. Luke's facility. Now, the injunction's only been in place for 28 days, and thus far we haven't seen those transfers happen, but we are certainly prepared for that.
Is there also a concern, Peg, that a patient would, as you said, have to go out of state, right? And I know when the injunction was not in place for a time, that was happening even at your facility, where patients had to be transferred out of state to get the emergency care they needed in order to save their health.
That's correct. During the process of this litigation that started in 2022, there was a 6-month time frame in 2024 when the injunction was stayed. And in those 6 months, we had 6 separate cases where physicians, in consultation with their patient, made the decision that they should go to a state where they could receive the full spectrum of care that was necessary given their medical condition. Um, that's not ideal for the patient in any way. You know, they're not, when you're transferred out of state, you're not seeing the doctor who you're familiar with. You
Mm.
likely are alone because your support system is not with you in this other state. You're in an unfamiliar hospital, seeing unfamiliar people. And we should never forget that when these situations occur, they are occurring for patients who have wanted pregnancies, and this is a highly
Hmm.
traumatic situation for them. So it adds to that trauma to then have to be transferred away from your home, your support network, your physician, to have to get the care that we're fully capable of providing here in your local hospital.
I want to talk next, Peg, about medical providers and what this means for St. Luke's medical providers. Can you begin with during that 6-month time frame, as you mentioned, where there was not an injunction in place, what did that look like for your emergency physicians?
Well, I think during the time frame that we didn't have the injunction, um, our emergency physicians, our maternal fetal medicine specialists, our on-call OB docs, were all quite concerned with making the right decision, offering the appropriate recommendations to patients, but then having to explain to patients that they may have to leave the state in order to get the care that was being recommended. So for our physicians, there's that tug of war between wanting and being fully capable of providing the necessary care for the patient and knowing that there's this law that prohibits them from doing so, or if they, in their own good faith belief, if that is questioned, that they could face a felony conviction. So
Hmm.
it puts physicians in an impossible position. They cannot comply with Idaho's law and comply with the requirements of EMTALA.
With this injunction in place now, what does this mean for your providers?
Well, I think not only for our providers, but really for our patients. It
Hmm.
means that that patients who come to our emergency rooms can get the care that our providers have the training and expertise to provide. And our providers can offer that care knowing that they are well within the bounds of the law to do so.
And Peg, what happens next? Like how long does this injunction stay in place? And I guess where are you in this lawsuit?
Sure. Yeah. The next step is we are talking with the state to come up with a schedule. We're, in the full throes of a trial, if you will, not in the sense that we are in court, but we are
Hmm.
going through what's called discovery. So the state will be able to ask St. Luke's a series of questions. Depositions will take place. And so we're on that path in the course of litigation. And while that is going on, the injunction remains in place.
Well, Peg, what do you want the primary takeaway for Idahoans to understand about this entire situation?
Well, I think primarily I would like Idahoans to understand that doctors want to take care of their patients, that the focus on the patients and the expertise that the doctors in Idaho have is paramount. So hopefully Idahoans understand that all we want is for doctors to be able to do what they've been trained to do. Um, I think secondarily, I think there's an opportunity for a change in Idaho's law that would take care of this issue by merely including an exception to Idaho's abortion law for the pregnant patient's health, an exception that would protect their health.
Well, and that's having an understanding that pregnancy is not black and white.
No, not
And
at all.
not even close. Well, Peg, really appreciate you coming on the program once again and to explain all of this to our listeners and also what this means for patients in Idaho and as well as medical providers within the St. Luke's health system. So thank you so much for taking time. I know how busy you are, so really appreciate you taking time to talk with us today.
Thank you, Gemma. I really appreciate you spending time on this important topic.
We've been speaking with Peg Doherty. She is the Deputy General Counsel for St. Luke's Health System. We've been discussing the latest injunction that is now allowing St. Luke's Health System to perform abortions in emergency situations. You've been listening to Idaho Matters from Boise State Public Radio. I'm Gemma Gaudette.